Good morning, students. We're now covering the second part of the Companies Act requirements. Remember that the first lecture material is available on e-learning, and that is for your self-study. Okay, so we're covering Chapter 2, or continuing with Chapter 2, the Formation, Administration, and Dissolution requirements. So in terms of Section 41, there's certain requirements that need to be met for approval of issuing of shares. Okay, so Section 41 states that there needs to be a special resolution in place if shares are issued to a director or a future director or a public officer or future public officer or any such related person or a nominee of such a person. Okay, the exceptions to this rule is when the issue of shares happens in terms of an underwriting agreement, it's in terms of preemptive rights, or it is in proportion to existing shareholdings, okay, where that existing shareholding and the new shareholding, they share the same terms and conditions as with the other shareholders, okay, or this new issue is in terms of an employee share scheme or in terms of a general offer to the public where these directors then take up that. Okay, so where shares are issued, where the shares represent 30% or more of the voting rights, then a special resolution is also required. Okay, Section 42 states that any option to acquire shares, okay, for shareholders, it requires a board resolution, or where those options are issued to directors, or where it's the 30% rule where one person would then hold more than 30%, a special resolution would also be. Okay. Important, Section 44. This is highly examinable, so please make sure that you are comfortable with the requirements of this section. Okay, so Section 44 talks about financial assistance for the subscription of shares. So when the shareholder or the prospective shareholder is expected to take up shares, and the company then provides financial assistance to do so. Okay, so the purpose of this financial assistance should be for the acquisition of the options or the shares. Okay, it could be for shares in the holding company or a subsidiary or a fellow subsidiary. Okay, so the requirements are that there should be a special resolution in place. The company needs to be able to satisfy the solvency and liquidity test. The terms and conditions should be fair and reasonable, and it should adhere to any of the MOIs. Okay. The exceptions are that where these shares are issued in the ordinary course of business, the financial assistance is issued in the ordinary course of business as a money lender. So if the company itself is a money lender, a bank, a financier, and where they give financial assistance as part of their ordinary activities, then these requirements do not have to be met. Or where the financial assistance is provided as part of an employee share scheme, where all of the employees are then subject to the specific conditions of the scheme. Okay, the financial assistance is void if it's inconsistent with this section of the Act or inconsistent with any of the provisions of the MO. Okay, Section 45 is similar to 44. It also deals with financial assistance. However, Section 44 is a general financial assistance, whereas 45 focuses on financial assistance to directors or related entities or related parties. Okay, so it has to be a director or an officer of the company or any related person, or a company controlled by the director. Okay, so if one company wants to buy shares in another company, and that first company is then controlled by a director, okay, or any of those related entities, okay, and then the company at hand provides financial assistance to acquire shares in itself. Okay, so once again, the conditions are for the solvency and liquidity test to be satisfied. Terms and conditions must be fair and reasonable. Okay, so it requires authorization, okay, where it is issued perhaps in an employee share trust. It requires then special resolution. Okay, The assistance is void, okay, if it's inconsistent either with this section of the Act or with any provision of the MOI. Once again, if your main business is money lending, then these provisions do not apply. It is an exception. Or if financial assistance is provided for legal expenses or other expenses incurred on behalf of the business, okay, and the financial assistance is provided to reimburse a director for those costs, or where there were expenses incurred for the removal of a director or a public officer at the company's request, then and if the financial assistance has a reimbursement of those expenses, then these requirements do not need to be met. Okay, so in terms of the resolution, it needs to be a written notice to all of the shareholders and trade union. They need to go out within 10 days if the value exceeds 1/10 of 1% of the company's net worth. Okay, that financial assistance that is provided. Otherwise, if it does not exceed 1/10 of 1% of the company's net worth, then it needs to go out within 30 days after year end. Okay, so section 46 talks about distributions and how it should be authorized by the board. When we talk about distributions, we're talking about payouts or dividends to shareholders. Okay, so distributions can be in terms of a court order or just a normal director's resolution. Okay, and the requirements are that the solvency and liquidity test needs to be satisfied, and that the fact that it is satisfied needs to be acknowledged through a board resolution, the fact that the solvency and liquidity test was passed. Okay, the distribution needs to happen within 120 days of that resolution, okay, where the solvency and liquidity test requirements were met. Otherwise, you have to re-perform the solvency and liquidity test if the distribution does not happen within 120. Okay, in terms of capitalization shares, where shares are issued 1-for-1 or in a ratio to existing shareholding, the requirements are that a director's resolution is required. Like I just said, it's issued one class of shares in respect of another. Okay, the shareholders can elect to receive cash instead of the shares. If that is elected, they exercise that election, then please do note that the solvency and liquidity test requirements also apply. Okay, section 48 talks about a share buyback. So the share buyback could be in terms of an existing legal obligation or a court order to do so, okay, or a director's resolution. Okay, just remember that the other term for share buyback would be a share redemption, okay, or shares being redeemed. Requirements, okay, once again, solvency and liquidity test, which is acknowledged by a board resolution. Okay, if the shares are bought back within 120 days, that is fine, but if it exceeds the 120 days, then we need to redo the solvency and liquidity test and then acknowledge that by virtue of a board resolution. Okay, could be that a subsidiary decides to acquire shares in a holding company, and if that is the case, not more than 10% of the issued shares of a certain class of shares may be acquired by the subsidiary. Okay, so any subsidiary may not then hold more than 10% of the shares in a holding company, and these shares do not carry any voting rights. Okay, a special resolution is required if the shares are bought back from a director, or if the shares represent more than 5% of the issued shares of that specific class of shares. If it's class A, class B, or whatever the case may be, if the number of those shares represents greater than 5%, then we require a special resolution. Okay, section 56 talks about beneficial interest in securities. Okay, this is where one person acquires shares on behalf of another person, okay, or a company acquires shares on behalf of someone else. Okay, so the section requires then for the identity of the beneficial person, okay, the person who receives these shares, the beneficiary, okay, that we need to disclose the identity of that person. Okay, the identity as well as the number and the class of shares that is held. Okay. If it is a regulated company, the requirement is to keep a register of all of the beneficial interests held, okay, and then within the financial statements, a list of persons that hold more than 5% of that beneficial interest within a specific class of shares that needs to be disclosed as well. Okay, so the rest of chapter 2 then covers governance of companies, okay, how shareholders are expected to govern or manage these companies. Okay, so 57 to 65 talks about shareholders' governance, okay, within the Companies Act. Okay, so shareholders can vote on any resolution. Okay, a resolution is just a decision that needs to be taken, okay, at a shareholders meeting, or they can vote by poll. Okay, they can have a poll that is running that needs to be in writing, and then that poll needs to then be finalized within 20 business days. Okay, even the election or the appointment of directors, that can also be conducted via poll. Okay, a statement needs to be issued describing the results of the voting within 10 business days then for the election of directors. Okay, if the MOI or if the MOI provides otherwise, the voting by poll is not allowed, okay, or in certain instances where the Companies Act also prescribes against it, okay. If that is the case, the voting needs to then be conducted at the AGM. Okay, so shareholders meeting can be called by the persons that are specified in the MOI or specific rules to the MOI, or by the board of directors. This is just a general shareholders meeting. Okay, but for an annual general meeting, okay, this is the meeting of the shareholders on an annual basis. The Act requires this to happen for public companies. Okay, this is a requirement within 18 months of incorporation. Okay, thereafter within 15 months of the previous AGM. Okay, so some matters can only be dealt with at an AGM. These include the presentation of the director's report, auditor's financial statements, the audit committee report, election of directors, except where we spoke about before, where it could have been conducted via poll, or then the appointment of auditors or the audit committees and any other specific matters that is raised by the shareholders. Okay, so the notice of these meetings need to go out 15 business days before the meeting in the case of a public company or a not-for-profit company, or 10 business days in any other case that is now for a private company. Okay, the notice needs to specify the date, time and place, the purpose of the meeting, and then any proposed resolutions, any proposed decisions that need to be decided on. Copies of those need to be issued together with the notice. Okay, if it is an AGM, okay, specific type of general meeting which happens annually, okay, a copy or a summary of the financial statements need to accompany that. Okay, and then also a statement that allows shareholders to appoint proxies. Okay, and then they need to indicate where they have appointed a proxy. Proxy is where somebody can vote on your behalf. So if I am a shareholder and I am unable to attend, I may then issue a proxy to one of the other shareholders who then can vote on my behalf as well. Okay, so in terms of the conduct at meetings, okay, a person that attends the meeting needs to identify himself, okay, and then the company's responsibility is to verify if the person is able to vote. Do remember that notices can be sent out electronically, and even the meeting itself can be conducted electronically. Okay, virtual meetings. Okay, this is now for the AGM or any of the general shareholders meetings. Okay, but do remember that if the MOI provides otherwise, that they may not do so, then they may not. Okay, section 64 talks about the quorum. Okay, so there needs to be at least 25% of all of the voting rights present at a meeting, sufficient persons to be able to exercise 25%. Okay. The MOI, however, can specify a lower percentage, okay, but as a minimum at least 25% or at least 3 shareholders if more than 2 shareholders are present. Okay. So if a quorum is not present at a meeting, okay, then the meeting needs to be postponed, okay, or adjourned for a week, okay. Then within a week, if the meeting reconvenes and no quorum is present, okay, then the members that are present in person or with a proxy, then they constitute a quorum by themselves. Okay, section 65 talks about shareholders' resolution. An ordinary resolution, okay, can be passed if more than 50% of the voting rights are exercised. Okay, so that is certain resolutions or certain decisions require at least 50% of the voting rights, okay, for it to be passed. Okay, then the decision takes effect. Okay, the MOI can increase the percentage, but not if it is in the case of a director's removal. Okay. Then for special resolution, where the Act requires certain decisions, for example, the financial assistance, to be conducted by a special resolution, special resolution then means that 75% of the voting rights need to be exercised in favor of this decision. Okay, but the MOI, the company's memorandum of incorporation, can specify a lower percentage, but at any given time there needs to be at least a 10% differential between an ordinary and a special resolution. Okay, so for example, for an ordinary resolution, the MOI could specify that 55% of the voting rights need to be exercised, and then for a special resolution, at least then 65% of the voting rights can be exercised to pass a special resolution. Then in that case, ordinary resolution was increased the percentage and the special resolution percentage was decreased, but at least we have maintained the 10% differential. Okay, so just a quick recap of what we have been covering in terms of Chapter 2 of the Companies Act. Okay, just ask yourself these questions to make sure that you understand what we have been covering. Okay, when is a special resolution required for the issue of shares? Okay, just go back a few slides and you will notice that this is when shares are issued to directors or future directors or any of those related parties. Okay. What's the difference between Section 44 and Section 45 relating to financial assistance? We've already covered this and we said that Section 45 specifically relates to financial assistance to directors, whereas 44 does not have those requirements. Okay, which companies need to have an AGM and when? Okay, we said that an AGM is a requirement for a public company, i.e. a listed company. Okay, and when? We said within 18 months of incorporation for the first AGM, and then 15 months of within 15 months every year for the next AGM. Okay, what is quorum? We said at least 25% of voting rights need to be exercised, and at least 3 shareholders where there were, if there are more than 2 shareholders present. Okay. What's the difference between ordinary and special resolution? We said that an ordinary resolution requires at least 50%, special resolution requires at least 75%, where the Act provides for the MOI of the company to be able to adjust those percentages, provided that a 10% differential is maintained between the two.